Hi, my name is Vic Monder. I'm a San Diego criminal defense attorney that practices both state and federal criminal defense. I'm making this video for my clients who want to understand the criminal procedure process from the beginning of the stages of their criminal case all the way to the end, either when it goes to a jury trial or we resolve the matter expeditiously with either the district attorney or city attorney, or if it's a federal case with the U.S. Attorney's Office. The initial stage in any criminal case is going to be the arraignment. That's when formal charges are filed against our client, and this is known as a complaint. This is a time when we plead not guilty to the charges that are in the complaint, and we set dates in the future to resolve the case, or if we want to take it to trial at that point, we go ahead and do so. This is a critical stage because a lot of clients come into the office believing that there's only one court appearance and then the case gets resolved. This is the beginning aspect of the case. This is where the games begin, is when we set these dates. Logistically, that's what the arraignment stage is for. The next stage after that would be the readiness conference. That's when we would get all the discovery in the case. If we need to continue it out to get more discovery, we will do so. On the felony cases versus misdemeanor cases, there is a stage after the arraignment, which is typically the preliminary examination in a felony case. This is a probable cause hearing, which will take place to determine whether or not there's enough probable cause with the witnesses testifying to bind over the charges against that defendant for a jury trial. What on the misdemeanor side type of cases, what we will see is that from the readiness conference, there will be no preliminary examination, and it will go straight to a jury trial. On misdemeanor type of cases, the clients do not have to be there. They don't have to be present. They typically will give us 977 authority to appear on their behalf. On felony cases, you are required to be there at each and every hearing and proceeding during the discourse of the actual case itself. What we see as criminal defense attorneys after the preliminary examination for any sort of felony proceeding is you will have one more chance to resolve the case before it goes to a jury trial. This will be another readiness conference. At the onset of the case, typically a client will tell us whether or not they want to resolve the case by taking any sort of classes or doing any sort of rehabilitation so they get the best possible outcome in resolving the case. And then there are also other clients that might ask us to take this case all the way to trial and not really understand why they were charged initially in the first place. We usually want to preserve our speedy trial rights for those particular clients that want to take it to trial, and we'll proceed on the case depending on the discovery as provided to us from either the city attorney, district attorney, or if it's a federal case, the U.S. Attorney's Office. Once we get to the readiness conference, we'll hash out every evidentiary issue that may come up in the discovery itself. There's a preconceived notion that clients will have that any statements made by witnesses is in itself evidence. This is not the case. In any preliminary examination, when we put a witness on the stand, under the penalties of perjury, any testimony that elicited from those witnesses is going to be evidence in the case. So we could get a better understanding as the case progresses whether or not the evidence is strong or weak against our clients. If you have any questions about the criminal procedure process up to the point when it begins to when it is finished, give us a call.